While this video series 105, we shall continue to discuss types of borrowers part 3. In this video, we shall be discussing Hindu undivided family and LLPs. And this is based on the JAIIB paper 2, Principles and Practices of Banking, module B. The topic is Functions of Banks, unit 22. Through a series of videos, we shall be discussing various topics based on JAIIB and CAIIB latest syllabus through small videos. It is certain that those who read and understand the topics covered in the videos will find it very easy to appear and pass in JAIIB, CAIIB and DBF examinations. So first we shall start discussing the Hindu undivided family. Under Hindu law, an HUF is a family which consists of all persons linearly descended from a common ancestor and includes their wives and unmarried daughters. And HUF cannot be treated under a contract. It is created automatically in a Hindu family. Hindu undivided family is treated as a person under section 231 of the Income Tax Act 1961. HUF is a separate entity for the purpose of assessment under the Income Tax Act 1961. Features of Hindu undivided family. A. Constitution of a firm. A HUF consists of male members descended linearly from a common male ancestor, together with their mothers, wives or widows and unmarried daughters, bound together by the fundamental principle of a family relationship, which is the essence and distinguishing feature. It includes all the members of the family, and the male member of the family gets right in ancestral property by birth. A major male member of HUF is called co-parsoner. B. Law governing HUF. HUF is governed by two schools of thought. Dayabhag law in Bengal and other parts of erstwhile Bengal province and Mitakshara law in other parts of India. The major difference between the two is in respect to the right over the ancestral property. In Mitakshara law, the right over the ancestral property is by succession, whereas in Dayabhag law, the son acquires the right over the ancestral property for the first time on the father's death by survivorship. The law governing HUF is codified under Hindu code, and succession among Hindu is governed by the Hindu Succession Act 1956. The Hindu Succession Act applies to any person who is a Hindu by religion in any of its forms or developments, including a Veerashaiva, a Lingayat or a follower of the Brahmo Samaj, Pradhana Samaj or Arya Samaj, to any person who is a Buddhist, Jain or Sikh by religion, and to any other person who is not a Muslim, Christian, Parsi or Jew by religion, unless it is proved that such person would have been governed by the Hindu law or by any custom or usage of that law for any of the matters in that if the act had not been passed. The Hindu Succession Amendment Act 2005 has given equal rights to male and female in the matters of inheritance, so a daughter also acquires status of co-parsoner in a HUF. In view of this, in the absence of any male member, or if all male members is or are minor, a Hindu female member can become Karta or manager of HUF. Status of HUF. A HUF cannot be termed as a person but is a group of persons. HUF has its own PAN issued by IT authorities. It is necessary to know whether an HUF is formed under Dayabhaga law or Mitakshara law. Management of business of a HUF. In a HUF, As long as members remain undivided, the senior-most male member of the family, called manager or karta, is entitled to manage the family properties. Upon the death of the karta, a male co-parsoner can become karta. However, a male minor can act as karta of HUF through his natural guardian. In case of disagreement among the co-parsoners as to who should be the karta of HUF, a court may appoint a karta till such time the co-parsoners decide about their choice. Karta occupies a position superior to that of other members insofar as he manages the family property or business or looks after the family interests on behalf of other members. This authority comes to a person by birth and he does not owe it to the consent of other co-parsoners. The liability of the karta is unlimited, whereas the liability of the co-parsoners is limited to their share in the joint family estate. When the adult co-parsoners join the contract themselves along with karta or ratify the contract entered into by the karta, they become personally liable for the loan. Banks prefer to get all the documents executed by the karta and co-parsoners apart from obtaining the HUF letter. The karta has the authority to borrow money for the family or ancestral business, but the burden of proof regarding necessity for a loan for the family purposes or not lies on the lender. Alienation of HUF property, that is transfer of value by the karta made without legal necessity, is not void but voidable at the option of other co-parsoners. They may affirm or repudiate such action of karta. Powers and duties of the karta. A karta has the following powers and duties. Powers: right to possession and management of the joint family property, right to income from joint family property, right to represent the joint family, right to sell the joint family property for family purpose. Duties: duty to run the family business and manage the property for the benefit of the family. Duty to account for the income from the joint family business and property. Banker and his dealings with the HUF. Bank dealing with a HUF should know the karta and ensure that karta deals with the bank and borrows only for the benefit of joint family business. The application to open an account must be signed by all the members and all adult members should be made jointly and severally liable for any borrowings or the account being overdrawn. Having understood HUF, now let us go to the limited liability partnership. A limited liability partnership LLP is a body corporate under the Limited Liability Partnership Act 2008 and is separate from the partners. LLP has perpetual succession. Any change in the partners does not affect the existence, rights or liabilities of the LLP. An LLP shall have at least two partners. Any individual or body corporate may be a partner in an LLP. LLP shall have at least two designated partners, of whom at least one must be resident in India. An individual cannot be a partner if he has been found to be of unsound mind by a court and the finding is in force. He is an undischarged insolvent, or he has applied to be adjudicated an insolvent and the application is pending. It is capable of the following in its own name: entering into contracts, acquiring, holding, owning or disposing property, suing and being sued, and doing and suffering as a body corporate can lawfully do and suffer. The LLP is a separate legal entity, is liable to the fullest extent of its assets. Liability of the partners is limited to their agreed contribution in the LLP. No partner is liable on account of the independent or unauthorized action of other partners. Mutual rights and duties of the partners within a LLP are governed by an agreement between the partners or between the partners and the LLP, as the case may be. The LLP is not relieved of the liability for its obligations as a separate entity. The incorporation document and other information is filed with the registrar of the state where the registered office is situated. Small limited liability partnership, the contribution of which does not exceed 25 lakh and the turnover of which for the immediately preceding financial year does not exceed rupees 40 lakhs. Banks may consider taking the following indicative list of documents for opening an account of LLP: Certificate of Incorporation of LLP, PAN of LLP, Registered Office Address Proof, PAN and Address Proof of all partners of LLP, and LLP Agreement. Having understood the HUF and the LLP, I request all of you to subscribe to my channel, which is totally free of cost. Subscription will give you intimation on the new videos being published. More videos based on JAIIB and CAIIB syllabus are to be published. Thank you very much. Your YouTube channel name is NPIS Learning Modules on Lending.